New Jersey has one of the most complex rent increase regulatory frameworks in the country, second only to New York in its layered complexity. The reason is that while New Jersey doesn't have a single statewide rent control statute, the state has allowed, and even encouraged, municipalities to enact their own local rent control ordinances. The result is a patchwork of over 100 local rent control ordinances across the state, each with its own rules, caps, exemptions, and procedures. If you own rental property in New Jersey, knowing exactly which rules apply to your specific property is the most important thing you can do. The governing state law is found in New Jersey Statutes Section 2A 42-84.1 and following, which authorizes municipalities to adopt rent control. The state also has the Anti-Eviction Act, Section 2A 18-61.1, which, as we covered in our New Jersey lease termination video, prevents landlords from evicting residential tenants without just cause. The interaction between the Anti-Eviction Act and local rent control creates a uniquely protective environment for New Jersey tenants. Let's start with the local rent control landscape. Over 100 New Jersey municipalities have enacted rent control ordinances, and each one is different. The specifics vary dramatically from town to town. Some cap annual increases at a fixed percentage, such as 3 or 4%. Others tie the cap to the Consumer Price Index. Some allow a base increase plus a CPI adjustment. Others use a formula that considers the landlord's operating costs. And some have hardship provisions that allow increases above the cap if the landlord can demonstrate that costs have risen faster than the allowed increase. Here are some examples to illustrate the variation. Jersey City caps annual rent increases at a percentage determined by its rent leveling board, typically tied to the CPI. Newark has a rent control ordinance that limits increases for covered units. Hoboken, one of the most expensive rental markets in New Jersey, has rent control provisions that affect a significant portion of the city's housing stock. Fort Lee, East Orange, Elizabeth, Bayonne, and dozens of other municipalities each have their own ordinance with their own specific provisions. This means that a landlord who owns properties in multiple New Jersey municipalities could be operating under completely different rent increase rules for each property. There is no shortcut. You must research the specific ordinance that applies to each property you own. For municipalities that do not have rent control ordinances, and there are many, particularly in the more suburban and rural parts of the state, the landlord can raise rent based on market conditions without a cap. However, even in municipalities without rent control, the procedural requirements and restrictions we'll discuss still apply. For properties not subject to local rent control, the landlord must provide advance written notice before a rent increase takes effect. New Jersey does not have a single statewide notice period specifically designated for rent increases, but the general practice, and the standard applied by courts, is that the landlord must provide reasonable notice before the increase. For month-to-month tenancies, this typically means at least 30 days written notice before the increase takes effect. However, and this is important, some local rent control ordinances prescribe specific notice periods that may differ from the 30-day standard. Some ordinances require 60 or 90 days notice. Landlords must check the specific notice requirement in the applicable municipal ordinance. The notice should be in writing and should clearly state the current rent, the new rent amount, the percentage of the increase, and the effective date. In municipalities with rent control, the notice may also need to reference the applicable ordinance provision and inform the tenant of their right to contest the increase. Some ordinances require the landlord to file the increase with the Municipal Rent Leveling Board or similar body before, or simultaneously with, notifying the tenant. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing midterm increases. When the lease approaches expiration, the landlord can propose a new rent. But in municipalities with rent control, the increase at renewal is also subject to the cap. This is a crucial point. Rent control doesn't just apply to mid-lease increases, it applies to the new rent amount when the lease is renewed. A landlord in a rent-controlled municipality cannot simply wait for the lease to expire and then impose a market rate increase that exceeds the cap. Now here's where New Jersey's framework interacts with the Anti-Eviction Act in a way that makes the state fundamentally different from most others. Because New Jersey is a just cause eviction state, a landlord cannot terminate a tenancy simply because the tenant refuses to accept a rent increase. In most states, if a tenant rejects a rent increase on a month-to-month tenancy, the landlord can terminate the tenancy with proper notice and the tenant must leave. In New Jersey, the landlord cannot do this. The tenant has the right to remain in the unit, and if the increase is above the local rent control cap, or if no cap applies but the increase is unreasonable, the tenant can challenge it. This creates a dynamic where rent disputes in New Jersey can become protracted. A tenant who believes an increase is excessive can file a complaint with the local rent leveling board, in municipalities with rent control, or can raise the issue in any subsequent legal proceedings. Landlords who push through increases that are perceived as unreasonable may find themselves in administrative or legal proceedings that are time-consuming and costly. In municipalities with rent control, the process for contesting an increase typically involves the tenant filing a complaint with the rent leveling board or similar body. The board investigates the complaint, holds a hearing, and determines whether the increase complies with the ordinance. If the board finds that the increase exceeds the allowable cap, the landlord must roll back the increase and may be required to refund any overcharges. Landlords in rent-controlled municipalities can typically petition for increases above the cap through a hardship application. The hardship process requires the landlord to submit financial documentation, including operating expenses, tax bills, insurance costs, debt service, and capital improvement costs, demonstrating that the property cannot generate a fair return at the current rent level. The rent leveling board evaluates the application and determines whether additional rent is justified. The process can be time-consuming and requires detailed financial documentation. Capital improvement surcharges may also be available in some rent-controlled municipalities. If the landlord makes significant improvements to the building, such as a new roof, boiler, or elevator, the cost may be passed through to tenants in the form of temporary or permanent rent surcharges, subject to the specific provisions of the local ordinance. The rules governing capital improvement surcharges vary significantly from municipality to municipality. Rent increases cannot be retaliatory. New Jersey has anti-retaliation protections under the Anti-Eviction Act and common law that prohibit landlords from raising rent in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability, reporting code violations, filing a rent control complaint, participating in a tenants organization, and exercising any right under New Jersey law. Because New Jersey is a just cause eviction state, the interaction between rent increases and retaliation is particularly significant. A landlord who raises rent dramatically after a tenant files a habitability complaint and the tenant subsequently refuses to pay the increased amount, cannot then evict the tenant for non-payment of the increase if the increase was retaliatory. Courts in New Jersey scrutinize this sequence of events carefully. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and New Jersey's law against discrimination, found in NJSA 10.5.1 and following, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity or expression, disability, familial status, marital status, ancestry, age, source of lawful income, or nationality. New Jersey's law against discrimination is one of the broadest anti-discrimination statutes in the country and provides extensive protections. The source of lawful income protection is particularly significant. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, Social Security disability, or other lawful income. A rent increase that appears targeted at tenants receiving public assistance can result in a discrimination complaint with the New Jersey Division on Civil Rights and significant liability. From a practical standpoint, New Jersey's rental market is one of the most expensive and competitive in the country. Driven by proximity to New York City and Philadelphia, strong employment centers, excellent schools, and limited developable land. The Gold Coast, Jersey City, Hoboken, Weehawken, and West New York, has some of the highest rents in the state, driven by direct access to Manhattan and a booming commercial and residential development market. Many Gold Coast municipalities have rent control ordinances that apply to older buildings, while newer construction may be exempt for a period of years. Landlords in these communities need to understand which of their units are covered by rent control and which are exempt. Newark, Elizabeth, Patterson, and other urban centers have rent control ordinances that affect significant portions of their housing stock. These cities also have active tenant advocacy communities and rent leveling boards that monitor compliance. The suburban communities of Bergen, Essex, Passaic, and Morris counties include many municipalities with rent control ordinances. Even communities that might seem affluent and landlord-friendly can have active rent control programs. Fort Lee, for example, has rent control that affects many of its apartment buildings. Central and South Jersey, including communities in Middlesex, Monmouth, Ocean, and Burlington counties, have a mix of rent-controlled and non-controlled municipalities. The rental market in these areas is influenced by proximity to New York, Philadelphia, the Jersey Shore, and regional employment centers. One critical best practice for New Jersey landlords: identify the rent control status of every property you own before implementing any rent increase. Contact the municipal clerk's office in each municipality where you have property and request a copy of the rent control ordinance, if one exists. Determine whether your property is covered, whether any exemptions apply, such as new construction exemptions or small landlord exemptions, and what the current allowable increase percentage is. This research is not optional. It's the foundation of compliant rent management in New Jersey. Another best practice, for properties in rent-controlled municipalities, maintain detailed financial records that support any hardship application you might need to file. Track all operating expenses, capital improvements, tax assessments, insurance premiums, and debt service payments. If your costs are rising faster than the allowable increase permits, having organized financial documentation ready for a hardship petition can make the difference between a successful and unsuccessful application. For New Jersey landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority in addition to complying with any applicable rent control cap. The housing authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. In rent-controlled municipalities, the increase must satisfy both the housing authority and the rent control ordinance. The more restrictive limit applies. New Jersey requires landlords to return the security deposit within 30 days of the tenant vacating, along with an itemized list of deductions and any interest earned. New Jersey requires security deposits to be held in interest-bearing accounts, and the tenant is entitled to receive the interest annually. Failure to comply with these requirements can result in the landlord being liable for double the amount wrongfully withheld, plus attorney's fees. For the complete guide to New Jersey rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.